Mhm.
All right. And it's giving us a message that says continue. So
Yes.
you can do that. I'm just waiting for the clock to tick to 4:03 on the computer,
Sounds good.
and we'll go.
All right. And I'm hoping everybody got the Zoom link because they sent it out, because she sent it out this morning to everybody who had registered. And I don't think I've seen any more. I better make sure. I'm going to,
Okay. Well, I'm going to go ahead and get us started.
yeah.
First of all, welcome everyone. My name is Beverly Moss, and I'm part of the Kemp Mill Village Events Committee, and so delighted to have you all on the call with us today. Throughout the year, the Kemp Mill Village has been holding a number of Zoom events to keep us engaged and to also give us a chance to learn some new things. So this is one of several events that we've had, and we are being recorded because all of our Zoom events are also on our website. So in case you missed it or you want to review, you can go to the KMV website, www.kempmillvillage.org. And probably tomorrow, probably, we will have this event up on the platform. You can go to it and listen to this and other previous events that we've had. The Kemp Mill Village has been helping our seniors during the pandemic and trying to make sure that we are doing the best we can to make sure that the elders in our community still have outlets, places they can go, things they can do, even though we're a bit limited right now due to the pandemic. Hopefully by the fall, we'll loosen up and things can kind of get back to normal. Again, my name is Beverly Moss, and today our event is called Planning Your Future and Your Children's Future. And today our guest presenter is Barry Fierst. He is a Maryland-based attorney concentrating on estate planning and elder law. He is based here in the Washington metro area. And one thing of note is that he has been recognized by the Washingtonian magazine as being one of the top elder law attorneys in the county. In his practice, he helped seniors prepare important documents such as wills, trusts, advanced medical directives, financial powers of attorney, and of course, provide other kinds of legal services to families, both with elders in them, people with disabilities, and I'm certain all kinds of other kinds of law. I'd like to welcome Barry and thank him for spending the time with us today. Really appreciate it because we know you've probably got a very busy schedule. And with that, I'm going to turn it over to Barry.
Thank you very much, Beverly, for your very kind words and for the opportunity to see and talk to people from my neighborhood. I like it. But first, I have to start with the lawyer's disclaimer and cautionary statement. Okay, like every lawyer, we always sort of qualify things. And in this situation, I want to make sure that people know that whatever I say may not necessarily apply to you. It depends on the facts and circumstances of your own particular situation. So please see what I'm going to be talking about as something very general. Also note that if I talk about the law, that is the law today. Tomorrow, the law may change again. So for example, today, President Biden signed the law regarding Juneteenth. And all of a sudden, tomorrow, things are changing. So the courts are going to be closed tomorrow in Montgomery County. And that wasn't the issue just a couple of days ago. That wasn't on the court calendar to be closed. So things change often and unpredictably. Okay, so I'm going to be talking for about half of the allotted time and leaving the rest for questions. So don't hesitate to think in your mind about what you want to ask me later.
And Barry, let me stop you there for just a minute. to remind people that we do have the chat feature at the bottom of your screen. You can click on a button that says chat, and you can type your question in. Also, you can unmute and ask a question of Barry. We try to let him get through a good part of his presentation, but definitely keep in mind your questions. We'd like it to be interactive after Barry gives his initial remarks.
Great. Okay, so I'm going to be talking about several different subjects that are sort of intertwined with each other. So I'm going to be talking about wills and trusts. I'm going to be talking a little bit about taxes, also about a financial power of attorney and advanced medical directives. Now, in order to sort of get a grasp on particularly wills and trusts, it's important to understand the definition of a particular word that some people think is a bad word, but it's not necessarily bad. The word is probate. Okay, so what I want to do is explain and sort of translate what probate is. Probate, in one sentence, which I will then try to parse, is the court supervised process of transferring assets from a decedent to the heirs. That's all it is. It's important to note that there are no federal probate laws. Zero. All probate laws are state-based. Maryland has its probate laws. Florida has its probate laws. The District of Columbia has probate laws. And in those three jurisdictions, I can tell you they are very different one from the other. So if you hear somebody talking, or whether it be a sort of an advertisement or commercial, or if you hear somebody on one of these national talk shows about having to avoid probate, please note that they may not necessarily be talking to you. They may be talking to people in a particular state because of the differences from one state to the other. Now, Maryland is on one end of the continuum for probate laws, and on the other end is Florida. Okay, so another question is, well, what jurisdiction controls? You may be domiciled and living in Maryland, but it could be that some of your assets fall under the probate process of another jurisdiction. It all sort of, as lawyers use the word a lot, it depends. Okay, so for people who are domiciled in Maryland, okay, and that's your residence for estate purposes, the state of Maryland would have jurisdiction over all of your assets wherever they're located, really in the whole world, except real estate. Real estate always passes under the jurisdiction of where it's sitting. So if somebody has a little condo in Florida and they're domiciled in Maryland, then, and they owned that condo in Florida, then there will be probate in two jurisdictions. Maryland will have what's called domiciliary jurisdiction, and Florida will have ancillary administration. Now, the process in Maryland is what we would refer to as streamlined. It's all the way on the end of the continuum for easy probate for most people, because Maryland has reformed its probate laws over the years so that most estates in Maryland can qualify for what's called modified jurisdiction and modified administration. So for those estates, there's only two different steps involved with the Register of Wills. One is the opening of the estate, which means submitting a number of forms to the Register of Wills, which may take approximately half an hour to complete. And then by the 10th month after the estate is opened, one has to file a final report. The final report is 4 pages plus 1 or 2 attachments. That's it for most estates in Maryland. In Florida, it's a whole different story. Even if the value of the condo was very small relative to the value of the Maryland estate. So to give you an example, someone came to me to handle an estate of someone who was a resident of Maryland, who owned a home here in Montgomery County, 2 bank accounts, and an empty lot in Florida. So we were told at one point at the height of the market in Florida that that property that was basically just an empty lot was worth over $10,000. But when the mother died, it was basically the bottom of the crash of the real estate market in Florida. And a real estate agent told us that she could maybe get $1,800 for it. Well, we handled the estate here in Maryland, and everything dealing with the transfer of the property and the filings and everything else, the total fee, and I'm using this just as an example, the total fee was not much more than $1,000. When one walks inside the office of the attorney in Florida, the meter usually starts at $3,000. So we said to ourselves, why don't we just let this $1,800 property go to the tax collector? Because we're not going to pay $3,000 to get an $1,800 asset. So that's what we did. We just let it go. Now, how could this have turned out differently? Okay, so let's go back to the definition of probate, the court supervised process of transferring assets from a decedent to the heirs. In this example, this real example that I told you, the mother owned the property in Florida. But let's say that somebody else owned it when she died. Okay, well, it certainly wouldn't have gone to the probate process. Let's say that it was owned by a trustee. Okay, let's say that the mother was the trustee of a trust, and she had in her trust document that her son would be the successor trustee. Okay, so in that situation, the mother dies. She didn't own that lot in Florida. It was owned by a trust. Okay, and then the son was the trustee, and then he decides to sell it. No big deal. No real cost at that time. There was, of course, a cost, to set it up. Now, in some situations, doing a revocable trust to avoid the probate process is not going to save much money. In this situation, it probably would have saved some money. But if the mother didn't own that lot in Florida, then probably the only person who would have benefited from doing a revocable trust would have been the lawyer, because the probate process without the lot in Florida was very simple and inexpensive and quick. But with the property in Florida, it was different. Okay, so it's very important to look at whether a revocable trust will be beneficial or not. One should not, as I get back to what I said before, listen to the advertisements and these national talk show hosts that say, oh, you got to have a revocable trust, because you got to look at your own individual situation. Now, there are sometimes other benefits from doing a revocable trust, and that is because a revocable trust is not just for when you are deceased, but it's also for when you are alive. So you put property in the trust, and you are your own trustee of the trust. If something happens to you and you're in a nursing home or you're no longer competent, then the trustee, the successor trustee, can step in and manage those assets. But there's a very big qualifier here. Okay, again, in listening to people who are advertising to do a revocable living trust, it's very important to know that there are two elements to make it work. One is the trust document. That's, what one typically goes to a lawyer for. Look at the trust document as a box. Okay, initially it's an empty box, just like that. What is in the box will be governed by the terms and conditions set forth in the document. So if the document says what's in the box in this trust is to be used for my health, education, and support, and for whatever I want, and when I pass away, it goes to my son, John, or to my son, John, and my daughter, Jean. Okay, that's great for what's in the box. But what happens to assets that are not in the box? And then the person, the grantor, the one who creates the trust, the mother in this situation dies. It's going to go through the probate process. Only assets that are titled in the trust will avoid probate. So that's the second step. The first step is to make sure that you have the box, and the second step is to fill up the box. Okay, so if the mother in this situation had created the box but never retitled the deed to that property in Florida, then that property in Florida would have gone through the probate process and would not have avoided probate. And that would have been another situation in which just the attorney benefited from it. So again, getting back to this issue of when does this revocable trust, it's important to also feed the trust, fill up the box with the assets. I will also note that it is very difficult to totally avoid probate anyway. So let's say you filled up the box. The Maryland, in this hypothetical that I was telling you about, let's say that the Maryland home was titled in the box, and let's say that the Florida lot was titled in the box, and this, controlled by the trust, and even the bank accounts. Okay, and then the mother passed away. Final tax return is filed with IRS, and there's a refund. Where does the refund go? It's not going to go to the trust. IRS does not write checks to a revocable trust. Okay, they will write it to the estate. So an estate would have to be opened anyway at the Register of Wills, a probate estate. Okay, so again, I'm going to move on to another subject, but I just wanted to make it clear that a revocable trust is not the end all. And also, actually, I want to add a couple more tidbits, is that over the course of the last dozen plus years, the legislature in Maryland has been closing the gap between revocable trusts and wills. Okay, so there's less and less a difference as time goes on. Okay, one change, which I believe was in 2015, is that the Maryland legislature set the creditor claim period on a revocable trust after somebody dies to be the same period as assets that go through the probate process. It's 6 months starting at date of death. It had been before that people thought that they could avoid some creditor claims by having their assets in a revocable trust, but that's no longer the case. Another difference is something which is referred to as either the elective statutory share or the augmented estate. And I'm going to tell you this only so one understands that this gap is closing. In order to fully understand this, we have to go back about 1,000 years. We have to go back to the king in England. And when the king said that when the husband died, he had to make sure that his wife was not impoverished. He couldn't leave everything he had to his girlfriend. So it was established that a certain minimum share after the husband died would have to go to the wife, the surviving spouse. And that carried on over to the colonies and was established as common law. And then the states then made into statutes. So for example, in Maryland, there's something called the Elective Spousal Share, in which if the first spouse dies, the surviving spouse can claim between 1/3 and 1/2 of the estate of the deceased spouse, regardless of what the will says. It could have been that the will left everything to the girlfriend, and then the surviving spouse can say, I want my share, and would get it. Now that law applied to what goes through the will or the probate process. And then it started to be pretty popular, 1970s, 1980s, and beyond, for some people to say, "Ooh, I'm going to take advantage of a revocable trust, and I'm going to disinherit my spouse, and I'm going to leave everything through my trust to my girlfriend or boyfriend or whatever." Okay, and that went on for years, and then the legislatures in the various states finally caught on and said, "Whoops, we're going to have to extend this law to cover revocable trusts." And in Maryland, that law went into effect last October. And we refer to it as the Augmented Share Law, which means that the surviving spouse can now claim between 1/3 and 1/2, depending on the circumstance, of what is not just going through the will, but also through a revocable trust. And there are certain other types of accounts also that the surviving spouse can claim from. So again, I'm saying this to note that the revocable trust is not the end all. Okay, so let's talk a little bit more about the will itself. And what are the different elements in the will? Because there are lots of different parts. Okay, one part is the tangible personal property. Do you have certain items, things that you can touch, that you would like to give to a certain person? Well, that is something that you can address in the will. Do you have any what we call specific bequests? Do you want to give a specific dollar amount to anybody, a niece or a nephew or a friend, or to a church or a synagogue or any kind of organization? Do that in your will. Of course, all these things you could also do in your trust if it's applicable, if that's something you would want to do. Another part of the will could address what happens if you have minor children or young children or adult children who aren't so good on managing their money. Okay, within the will itself, you can have what's called a testamentary trust. A testamentary trust, unlike a revocable trust, a testamentary trust comes into being, it is born actually only after the death of the person's will, or the person who signed the will. And you could say, for example, I leave whatever share to my son, John, but it's going to be held by a trustee until he's 35. When he's 25, he can get 1/3 of it. And when he's 30, he can get another 1/3. And while it's held in trust, my trustee can use the money for my child's health, education, and support. These are just examples of terms. You can have any terms you want. You can have the period of time that it's held in trust to whatever you want. That's fine. The most important thing here, though, is not so much the terms of the trust, but who's going to be the trustee. Who's going to be in charge after you pass away of the money that you're setting aside in this hypothetical for a child. There's a reason why the first syllable of that word trustee is trust, because you're going to have to find somebody who you can trust. And typically I tell people you're looking for somebody who's got good common sense and somebody you can trust also. But the good common sense means that somebody who would know when they don't understand something and knows how to find somebody to get proper advice and not be taken advantage of. That's the kind of common sense that I'm referring to in selecting a trustee. Another important element in the trust is what we call in Maryland the personal representative. Now, in most states and in the John Grisham books, we use the term executor. That's the person who is in charge of carrying out the terms of your will. That person would complete all the papers that need to be filed with the Register of Wills, then take control of all of your assets, pay the debts that are rightful debts that should be paid, file final tax returns, file the final documents with the Register of Wills, and then distribute the assets pursuant to the terms of the will. That's the personal representative. Now, in the will itself, there are other things that can be addressed. If you have minor children or a child with a disability, then you would want to include a provision in the document for the appointment of a guardian. Now, naming somebody in the will to be the guardian does not mean that that person is going to automatically be the guardian of your child. There still has to be a court proceeding. There's a particular type of court proceeding for a minor child and a different type of court proceeding for a child who is an adult but has disabilities and can't manage his or her own financial affairs or personal affairs. But the person who you would name in the document, in your will, would have priority over everybody else. Now, as an aside, I noted before that the revocable trust is the document that can be used to say who gets your assets when you die, just like a will can be. But there's certain things that are necessary in a will that you can't do in a trust. So in the will is the document where you would name a guardian, not in the trust document itself. And by the way, one other thing which I didn't note before, I did say that almost always there are some assets that go through the probate process because it's impossible to totally fill up the box but while you're alive. And that's why when you have a revocable trust, you would also have a will. That kind of a will is typically referred to in legal slang as a pour-over will, P-O-U-R. And what it does is it basically would say, okay, any assets that I failed to put in the box while I was alive, I want to have put in the box after I pass away. Or you could say, I just want them to go according to the terms of the box of the trust. So, but that will is very important, even though it's usually a very short document, in order to have this directed. And that will itself, this pour-over will, would have to be filed with the Register of Wills. Okay, I want to talk a little bit about what happens when you don't have a will. And I will unfortunately give you a war story, which is what lawyers say when they have, went through an event and they want to tell other people about it. But of course, we can't identify who it is. But I'm going to tell you, unfortunately, this is a real life story. So I handled the estate for the mother of a client of mine. And the mother had 2 children, but one of them had predeceased her. The surviving child, the daughter, was a very successful attorney. She had lived abroad for a number of years, and then when she came back to the States, she developed a practice in international contract law, concentrating on the country where she had been living. And she became fairly well settled. And at the time that her mother died, she already had assets in a value of about $7 million. And the daughter, my client, said, okay, I need to do a will. So I said, fine. So I drafted a will, which was fairly complex because she was not married, she had no children, and she was dividing up this $7 million into all different pieces. And her family, so I noted her brother had predeceased her. her brother had one son, and he had a girlfriend, and the girlfriend got pregnant. And then before the girlfriend gave birth, this, who was the nephew of my client, he died. Okay. Subsequently, there was a child born who was the great nephew of my client. In my client's draft will, we had a trust of $250,000 for the benefit of this great nephew. Well, my client reviewed the draft, and she eventually called me a year later and said, Barry, I just can't get my arms around this. It's going to take more time. Another year went by, and she called me and said, I'm still thinking about it. I'm going to make some changes to this, the draft. The following year, she passed away. She had no will. She had $7 million. If we totaled up all the people who were going to get little pieces out of the $7 million estate, it was about 20 people, but they got nothing. Well, 19 of them got nothing. The grandnephew or great nephew, he got the $7 million. He was 13 years old. So imagine what it would be under Maryland law. And that's what happens when you have no will. The state says who gets. And it's basically, without going into the weeds of the law, it's basically the closest relative, and that was the closest relative. And under Maryland law, if you're age 18, you get the money. Until age 18, Maryland law provides 3 different ways in which the money can be held. In this situation, the mother filed a petition to be guardian together with Sandy Spring Bank. So, and the mother lives in Chicago. And this child now is about to be 18 years old. This is a true story. He's about to come into this money. And there's no happy person in the world except for this child. Nobody is happy about it, neither is the mother. But under Maryland law, there's no way to hold on to it any longer. So that goes to the story of you need a will. Okay, that's a pretty extreme one. I'm going to segue a little bit to taxes. Okay, 2 different types of taxes that I'm going to be talking about, not the typical taxes that you pay every year, like income taxes or capital gains tax or anything like that. I want to talk a little bit about estate tax. Okay, fortunately for the vast majority of people in the country, they no longer have to be concerned about federal estate tax because of 2 different reasons. Number one is that the credit that the government gives you regarding estate tax, what I mean is the amount that somebody can have at the time of their death and not have their assets subject to estate tax on the federal level is now $11,700,000. So that already means most people don't have $11,700,000, and they're not going to have to be concerned about federal estate tax, which is good because the first dollar after the $11,700,000 is subject to a 40% tax. Okay, now this $11,700,000 is twice the amount that it was when President Obama left office, because that was one of the things that the Republicans did was they doubled the tax credit on the estate tax level. Also, this amount is linked to the cost of living index, so it changes every January 1st. But that was only one of 2 major changes that have evolved in the last years regarding federal estate tax. Another change is something which is called portability. It had been that lawyers would make money by having intricate clauses in wills and revocable trusts in order to what we say is capture the credit of the first to die spouse. Because what would happen is if the first to die spouse left all assets to the survivor outright, then the credit was lost. So when the survivor died, there would just be this single credit that could be applied. And the credit for many years was significantly less than this 11,700,000. So when I first started practicing, it was 600,000 was the credit, and the credit eventually became $1 million. And we go back to 2004, it was $1 million of the federal credit, and then it slowly eked up, okay, to what it is now. Now, the law that I'm referring to, which is relatively recent, this thing called portability, means that the surviving spouse inherits the credit without having to do any of these fancy clauses that lawyers would put into the documents. So now you can have a will that leaves everything outright to your spouse. And then when the spouse dies, the spouse can leave 23,400,000, twice the individual credit, and there'd be no estate tax. No federal estate tax. Okay, that's one of three things I want to talk about. The second tax is the Maryland estate tax. Okay, the Maryland estate tax changed significantly on January 1st of 2019. And on that day, Maryland adopted portability, the portability rule. So again, lawyers are making less money because the lawyers can just do sort of basic wills, leaving everything outright to the surviving spouse, because the surviving spouse inherits the credit. Okay, the Maryland credit, though, is significantly lower than the federal credit. The Maryland credit is $5 million. But with portability, the surviving spouse can pass $10 million in a net estate without having any Maryland estate tax at all. So again, most people aren't concerned anymore about this tax. The Maryland credit, while now you can pass 10 million, it used to be 1 million, just going back to 2014. The Maryland credit was $1 million. So you can see there's been significant changes in the estate tax credits in the intervening time. Okay, now I want to talk about the third tax, which may apply a little bit more to people. Maryland has an inheritance tax. It's different than estate tax. Estate tax is a liability of the estate, of the assets that are left generally by the person who died. Inheritance tax relates to the person who is actually inheriting it. Now, the Maryland estate tax, excuse me, Maryland inheritance tax has evolved throughout the years, and since I started practicing, it's changed several times. So again, I'm telling you what it is today, but it may change. Expect that it's going to change in the future. Most states do not have an inheritance tax. I would believe there's probably only about 10 states left, and there's probably only about 10 or 13 states left that have even an estate tax, but Maryland's got both. Okay, so inheritance tax, to differentiate from estate tax, is imposed depending on the relationship between the decedent and the heir. Most people are exempt from inheritance tax. Spouses are exempt. Descendants, children, grandchildren, great-children are exempt. Siblings are exempt, and ancestors, parents, grandparents are exempt from this tax. But who's not exempt? Well, a sibling may be exempt, but nieces and nephews are not. So if the decedent left anything to a niece or a nephew, then there would be inheritance tax applied, and that inheritance tax is 10%. So it's important to note that if you want to leave money to a favored niece or nephew, there's going to be 10% tax, and then you have to figure out who's going to pay the tax. Is it going to be the, come out of the, what we call the residuary estate of the, under the will, or is it just going to be a reduction and paid out of this gift that's going to be made to the niece or the nephew? So when the attorney meets with the client and the client says, I want to give money to my favorite niece, the attorney would say, well, maybe to the niece's parents so there won't be tax, and hope that the parent, your sibling, will give the money to the niece and then avoid that 10% tax. So those are the taxes to be considered. Okay, now I've talked about trusts and I've talked about wills, talked about taxes. I want to segue to the two we refer to as ancillary documents. The first one is a financial power of attorney. So what happens if you are hit by a truck in a nursing home and someone's got to pay your bills? What happens if someone needs to file a lawsuit against the truck driver that hit you? Who's going to sign your tax return? Someone needs to access what you have in your safe deposit box. Someone needs to sell your home, okay? And you're going to move into a smaller place or a larger place. Well, that can all be done through the financial power of attorney, okay? If you don't have the financial power of attorney, which is a very simple document to produce, then the alternative sometimes is having to file guardianship. So let me give you a prime example of a couple that own a home. They own it together. And then the husband got hit by the truck and went into a nursing home. Okay. And is no longer able to manage his financial affairs. And the wife says, we are going to have to move to a home that doesn't have floors. I want to move to a ranch home because my husband's going to come back and he's going to have difficulty now doing the steps. Okay. Well, if they want to sell the home and you own it jointly, then both the husband and wife will have to sign the deed. But the husband can't because of what happened to him in being at the nursing home. So who can sign the deed? It's either the person who's the agent under the financial power of attorney, which, a lawyer usually drafts for, $75 or something like that. Or if there isn't a financial power of attorney, then one would have to petition the court for guardianship or for what's called an order for a single transaction, which would cost thousands of dollars. So it's better to do the financial power of attorney. You can name your spouse, you can name an adult child, you can name a friend, anybody you want who goes back to what I was saying about the important characteristics in someone you can trust. The person you can trust and someone who's got good common sense. The other ancillary document is referred to as advanced medical directives. It does have sometimes alternate names to it, but this document typically has two different parts. The first part is the appointment of the healthcare agent. This is usually somebody who, if you cannot communicate, is somebody who can admit or discharge you from a healthcare facility, review your medical records, be recognized under federal law as what's called a HIPAA agent, and somebody who can interpret your wishes if they're ambiguous. The second part of that document is referred to sometimes as a living will. And in that section, you would say how you want to be treated when you cannot communicate and you're only surviving because you are on life support. On top of that, you have been deemed to be in a persistent vegetative state or end stage condition, something we don't really like to talk about, but this is the situation in which you can decide in advance how you want to be treated, as opposed to having somebody else decide how you want to be treated. Now, these two ancillary documents, the financial power of attorney and the advanced medical directives, serve two very important parts of your life. Without them, there could be significant costs. I want to differentiate between them, though. The advanced medical directives, while there is what we call a Maryland statutory form, you don't have to use it. Okay, there are a variety of different forms that are used. They could be, some religious organizations put out their own forms. There's something called the 5 wishes, which you can review on the internet, which is a more detailed way of saying how you want to be treated when you cannot communicate your healthcare wishes. So basically, you just have to have the form which is executed in a way which is recognized by the law, which is generally speaking 2 adults, 18 or older, who are not healthcare providers. There are just certain rules about ensuring that the document is done in order to make it effective. Even the Maryland statutory form, when I give it to clients and they take a look at it, they say, can I change this? And I say, sure. So we modify it. So just as an example, on the part that says, if I'm in a persistent vegetative state and there's no expectation that I will ever be aware of my surroundings again, and I'm living only because I'm connected to a respirator, then disconnect me. Well, some people say, well, how about if I say disconnect me after 7 days? And I say, sure, you can do that. So we modify the document. With the financial power of attorney, that's different. Okay, Maryland adopted the Uniform Statutory Power of Attorney Act in 2010, and it's been changed or modified several times since. Before that date, when this law went into effect, October 1st of 2010, the power of attorney law in Maryland consisted just of a few sentences. And so lawyers would draft the power of attorney document to make sure that it complied with those few sentences. And then when the time came, the agent would go to the bank or the financial institution and say, well, here's this document. I need to manage the account of my father. He can no longer manage his financial affairs. And then the bank would take a look at it, and sometimes they would send it up to their legal department and determine whether it complied with those few sentences in the Maryland law. Well, Bank of America got tired of doing that. And so they said, well, from now on, you're going to have to do it on our form. If anybody wants to use a power of attorney at Bank of America, you have to use our form, because we're tired of sending it up to our legal department to determine whether it complies with the state law in effect where the branch is located. Well, the lawyers didn't like that. So that's when this uniform law legislation was put together. You may be familiar, there are other uniform laws. Most people know the Uniform Commercial Code. Okay, this is another one of those in which there's a piece of legislation put together and the various states are asked to all pass the same thing or something as close as possible to have uniformity across the country. And Maryland adopted this in 2010. And the law, basically what it did is it put two forms in the code, and the Maryland code. And the code says that if a financial power of attorney document is substantially similar, keywords here, to one of these two forms, then the financial institution must honor it. As an aside, Bank of America, they fought this with their lobbyists in Annapolis, but it was after a few years, it was finally passed. And so if you go to an estate planning lawyer in Maryland now, we're going to be using one of those two forms to make sure that Bank of America and all other financial institutions that have any connection to the state of Maryland, that they have to honor that document. Okay, I think I've talked my 45 minutes or so. So I am ready for any questions that anybody may have. I guess I was very thorough.
I do have a couple in the chat, and we'll start with
Okay.
that. And I'm hoping that we'll have some more as well. I can certainly throw in, but here's, I think you may have touched on this, but the differences between a trustee and an executor, and how do you find out more about the roles of the trustee versus the executor?
Okay. The role of the executor relates to the will. And the executor, what I'm going to change that term to personal representative, because
Right.
that's
That's
under Maryland law.
that's what I thought.
Okay. So that person may be appointed through a will and say, I want my spouse or my friend to be personal representative. And it's meaningless really until the person dies, until the what we call the testator, the one who signed the will, until that person dies. Then the person who's named in the will as the personal representative will file the will together with the petition for probate at the Register of Wills, and event, we usually in non-COVID times, 2 or 3 days later, the Register of Wills will issue letters of administration, and that person will have been actually legally appointed as the personal representative. And that role is just to carry out the terms of the will. And it is it's somewhat of a time-defined period from between the appointment until the final report or the final accounting is filed with the Register of Wills and the money is distributed. Usually it's something which is less than a year. A trustee is different. Okay, first of all, it depends on the type of trust, but let's talk about the revocable trust. Okay, so let's say that I did a revocable trust and I could have said, well, okay, I'm doing a revocable trust to hold my assets. I'm also going to have a co-trustee. I'm going to name Karen as my co-trustee. And I may be able to say, well, we can act independently. We'll just make it like a joint account, just like we have a joint checking account. And that works. So in that situation, the trustee is acting already while the person's still alive. Okay. And then, many years from now, we're 120 and we pass away. And at that point, the successor trustee will take over. And I may have had a trust created in my revocable trust for the benefit of my grandchildren. And there'll be a trustee in charge of that. And then the terms of my trust for my grandchildren may say, well, I want that money held until my grandchild is 40 years old. So the role of the trustee basically can continue for a long period of time, depending on the terms of the document. The role of the personal representative or executor is much shorter. I hope that sort of addresses the question.
All right, we have a good question here now. Is a will necessary if you've already taken, all of your accounts have financial beneficiaries already in place? Do you then, since you've already taken care of that, do you need to draw up a will as well?
Okay, yes. For a variety of reasons, is you want to make sure there's no confusion as to who can sign the final tax return. As simple as that. Okay. Sometimes people want to have burial instructions or say who's in charge, and that would be through a will. And then there's also what I referred to before as if there's a refund from IRS, or the car was sold and Geico was going to refund the balance of the premium, which they do. Okay. Or someone canceled the subscription to the Washington Post and there's a refund. Or somebody's getting money based on filing a claim on a health insurance company, and they're finally paying. A real example is last week, we finally got money from a claim that was filed 2 years ago when our client passed away. And the money only just came in last week. So where does the money go? Well, you can't go to a named beneficiary, off of an account. It's got to go according to the terms of the will. Now, the will can be very simple, but you really need a will.
All right, I'm going to ask a question because and this is sort of something that happened. And I'm sure a lot of us have family members who are not Maryland residents. So if you have a power of attorney and say you were to give it to a child who lives in New York, or vice versa, if I'm thinking, I had one with my mother, I was growing up in New York. At any rate, with advanced directives and financial power of attorney, if you draw it up in one state, is it going to be valid in the next, the other state? What if you move or another person is in the, is it not in the same state?
Okay, so other states are supposed to recognize the power of attorney document that you've done. But I will give you an example of something that happened today, okay, with the power of attorney. Okay,
wow.
And New York. Okay, so I have a client whose mother is from New York, and she signed the New York statutory form, because New York has had a statutory form for many years. And it's
Correct.
basically just check off different things that you want.
Mhm.
And so the daughter went to Capital One Bank with the New York document, went to Capital One Bank here in Montgomery County and said, can you add me as an attorney in fact on my mother's account? And they said, no, we don't like this power of attorney document. And they do it on their own form, which they could do. Now, if they had the Maryland statutory form, then the bank is now required to honor it. So for that particular client, who fortunately the mother is still has capacity, she lives at Revit's house, and she fortunately has capacity to sign a new power of attorney. That's what we're going to be doing. So on one hand, the power of attorney document is supposed to be recognized in other states, but New York doesn't have that, in which it requires the financial institution to honor it. If they did, then then push comes to shove, Capital One would have had to have accepted it. But the Maryland form, I would say, is probably valid in Maryland and 48 other states. Lawyers will always say that if you're in Louisiana, make sure to go to a lawyer there to check all of the documents that you have. Without getting into the quirks of Louisiana, which is based somewhat on French law, actually. But okay, hope that answered that one.
All right, Karen asks, if I write a will tomorrow, can I lock it away until I die at, let's say, 100 years old? 120, odd may of mystery. Okay.
Okay, if you do a will today, and you never revoke it, and the document's still around for 50 years, it's still valid. We've handled in our office wills that were done 50 years ago, and they're still valid if they were never revoked. The issue sometimes arises. That's good opening for another thing here. The issue sometimes arises if no one has the original will. Okay, so in order to go through the process of what's called administrative probate, okay, now there are different ways that the probate goes. I was talking before about modified administration, but within the modified or regular administration, there's also a division between administrative probate and judicial probate. If one has the original will and nobody contests it, then it's going to go through administrative probate, and it's not going to go before a judge until towards the end of the process. If one doesn't have the original will and all you have is a photocopy, then the process will start through what's called judicial probate, and a judge is going to make a decision as to whether the photocopy is the same as the last original and that it was not revoked. Now, Maryland law in this regard changed about 7 years ago. So there's two ways to get a photocopy accepted. Before there was only one way. So I'll tell you both. The prior way, which still exists, is if you have a photocopy, then there has to be a hearing and a notice in the newspaper before the hearing to allow anybody who wants to come to the hearing to show why the photocopy should not be accepted. So this is called a hearing to show cause. Okay, and I've unfortunately been to a few of those. The craziest one we had in Baltimore County, in which this is an extreme case, but sometimes it's an extreme case to show what happens. So this person actually had been murdered, and his house was put on fire and was significant damage, and the original will was not found. The lawyer who wrote this, an out-of-state lawyer, had the photocopy, and we submitted the photocopy, and we had to go through the hearing process. In this situation, the will was not signed in Maryland. We flew in the witnesses to the hearing, and we went to a 3-judge panel very, very unusual. But the most unusual part of this is that in this procedure, Maryland follows the European system in which the judge asks the questions. In this situation, it's the judges. So there were 3 judges and they asked questions of each witness. And then they want me to have the personal representative on the stand who wasn't even there at the signing of the will. Anyway, so fortunately, they signed the order accepting the photocopy, which was very different from what would have happened if there was no will at all. If there was no will, then everything would have gone to the mother because the decedent was not married, no children, and the mother was in a nursing home being paid by Medicaid. And so that the will fortunately was held and it went to other people in the family. Okay. So that's one way. Another way, which again became law in Maryland, I think it was about 7 years ago, was that if all of the interested persons, in other words, those named in the will and those who would have inherited if there was no will, sign a petition, then a judge can sign an order without a hearing. So to get back to the original part of this segue is make sure to keep the original will in a safe place. A safe place could be in a fireproof box at home. Some people have a safe deposit box. The Register of Wills will keep wills for safekeeping. You pay them $5 and they'll keep the will there forever. There are some attorneys that keep original documents for their clients, but some attorneys that I know will only do it if the client is at least 80 years old. Hope that addresses that question. Yeah.
I was going to say, ask something else, and we got a good question about how often you review your will but I have a question about the safe deposit box. Aren't they locked at the time of death so that if you have the will in there, you can't get at it?
Okay.
Or is that not in Maryland?
I was just about to say it depends on the state.
Yeah.
Okay. In Maryland, it's relatively easy to get into a box after somebody dies to retrieve the will. First of all, if there's a co-owner, it's never an issue.
Mm-hmm.
Okay. Secondly, let's say there's no co-owner, but somebody believes that there is the original will exists in the safe deposit box. Well, then one goes to the Register of Wills and asks for an order to have the box opened. The Register of Wills then has the option of saying, well, that's fine, but we need to coordinate when someone from the Register of Wills is going to be at the box when it's opened. But that's a procedure which we've gone through, and it's really not a big deal at all. Not a costly way to go about. The cost is involved when nobody has the key. So it's not the legal authority so much, it's having the key. So this isn't exactly on point, but I was involved in an estate in which I was the personal representative, and we had the will, but there was also a safe deposit box. Okay, I had legal authority to get into the safe deposit box, but nobody could find the key. And this was at the SunTrust branch off of Old Georgetown Road. And so we had to pay the bank $250 and coordinate with a locksmith to be there to drill it open. There were also other parts of that issue, but having the key sometimes is more important than anything else because there is a way to get access.
That's if you can find a safe deposit box. Most banks today are doing away with them entirely. You can't even get one.
That's correct. Yes, fewer and fewer or have those boxes.
What's the alternative? Is there another place to keep things?
Well, the only other alternatives I can suggest besides having the fireproof box at your own home is the Register of Wills. You pay them $5, they'll keep the will forever. But the problem with the Register of Wills is they will only keep wills. Okay, they won't, if you have a revocable trust, financial powers of attorney, any other document, they won't take it. They'll only keep the will. So it's again, some lawyers keep original documents. At our firm, we only do it if you're at least 80 years old. But the other alternative, most people keep it home in a fireproof box.
Under what circumstances should you review your will? In other words, what life events? I think that's what we're getting at here. What life events would make you want to look at your will again?
Okay, so the rule of thumb that lawyers usually tell their clients is the first to occur of 5 years or some significant event, a death of somebody who was very involved in the document, or somebody who you named as your agent is ill, or you won the lottery, or anything like that. Otherwise, every 5 years. And when I first started practicing, and I heard every 5 years, oh yeah. So, people probably don't have to do that. And then as time went on, I saw the laws kept on changing. And I saw that I had some clients that really needed to change their documents. And there was a period of time, not to get too much into the weeds or the legal trivia, but back in 2004, Maryland cut the tie with the feds regarding estate tax. So the federal estate tax credit was all of a sudden different than the Maryland estate tax credit. And without getting into the weeds of it, it caused potential significant problems in some estate plans. By the way, that lawyers have been drafting the documents over years, presuming that there would always be this link between the Maryland estate tax and the federal estate tax. But then they cut it so that the credits were different and still different. So then lawyers had to draft documents a whole lot different. And back in 2004 and 2005, there were a number of estate planning lawyers that, felt they had to send out letters to all their clients saying, come on in, you got to make a change. And it wasn't, those letters didn't go out in order to drive up business and so the lawyers would make money. Those letters went out so the lawyers wouldn't have to go after their legal malpractice policies because of the change in the law. Anyway, so that's it. If you have a will, it shouldn't just gather dust. It's nice if it gathers dust, meaning it doesn't have to be used, but it needs to be reviewed regularly.
We have a question about the difference between a revocable and an irrevocable trust.
Okay, so there's a lot of differences, obviously. So, because one, in a revocable trust, you can revoke it. In an irrevocable trust, you can't. But I will note one thing. A revocable trust, when the grantor, the one who creates it, dies, automatically and immediately becomes irrevocable. A revocable trust can always be amended. An irrevocable trust, maybe not. Okay. In a revocable trust, the assets held in that trust are deemed by IRS to be still owned by the grantor, the one who created it. So if you have a revocable trust, it will use your own Social Security number, and you will report all of the income generated by the revocable trust on your own personal tax return, your income tax return. And that's why creating a revocable trust sometimes is, there's no significant tax event until you pass away. When you pass away, it becomes irrevocable. And when you pass away, it can no longer use your Social Security number because Social Security numbers are used only when you're alive. At that point, it uses what's called an EIN. It's used to refer to an employer identification number. Thank you. But since it's not just for employers, for many years, it's just referred to as the EIN. And then it's reported on a separate tax return and becomes a little bit more complicated. Another thing about a revocable trust, which again is the vehicle to use to avoid the probate process, is that assets held in a revocable trust receive a step up in what's called the cost basis when the grantor dies. It's a great tax benefit. Even assets that are held that pass through a will receive this step up in cost basis when the decedent dies. That's the only thing that the government really gives you when you die. The step up in cost basis, which will reduce or eliminate potential capital gains tax. Money in an irrevocable trust, depending on the trust, but most irrevocable trusts, the assets do not receive a step up in cost basis when the grantor subsequently dies. Now, most people, but I'm saying most, certainly not all, when they create a trust, it's a revocable trust. Again, a revocable trust does become irrevocable when you pass away. There are other kinds of trusts that would be irrevocable when you start it. There is a type of insurance trust which will be done, and that will always be irrevocable. It used to be more people would do an insurance trust before than now when the credit against estate tax is so high. But when the credit against the state tax was lower, then people, of course, would look for ways to have their assets avoid the estate tax. And with insurance policies, when the owner of an insurance policy passes away, the value of that insurance policy is included in that person's estate for the purpose of calculating estate tax, even if the decedent never had the money. So I have some clients that may have an insurance policy, even if it's term policy of $500,000 or even $100,000. If they own that policy when they died, even if they never had a penny of it, the total value, the proceeds, the 500,000 or the 100,000, whatever, is added to the value of the estate in order to calculate the estate tax because that person owned it at the time of death. But this other kind of trust that I was alluding to, this irrevocable trust, it's sometimes called an ILIT, Irrevocable Life Insurance Trust. If the ownership of a life insurance policy is transferred over to a trust so that the person who is insured no longer owns it, then after a certain period of time, if that individual passes away, it's no longer included in his or her estate because it was owned by the trust and not by the person who died. Okay, so I'm sort of getting into the scene of there are lots of different kinds of trusts. They're revocable trusts, they're irrevocable trusts. Each one serves a different purpose. There's also special needs trusts. Most special needs trusts are irrevocable the way they're done for a variety of reasons. Not the same reason as the life insurance trust, which is done for tax purposes, but there are other reasons why a special needs type trust would be irrevocable. The world of trusts is big. There are lots of different types and they serve different purposes. Other questions, Fanny?
I suppose actually this was a little bit left field, but it just came up recently. My mother has been gone for 2 years. There was really nothing in her estate at the time. She was on Medicaid, yada, yada. I don't know how this plays in, but we're about to find out whether indeed there are a couple of grave sites that she owned that were not, maybe one, maybe two. One was transferred by a great uncle, and it was in her. There's an amendment form in there. I don't know. I'm assuming. First of all, I don't know. Can you sell a grave site? What would you do with the proceeds? I'm assuming also that if it's the estate's been long settled for 2 years, that there wouldn't be any consequences. But I guess what I'm saying is a lot larger issue is what if you discovered that there are assets that you didn't know about when you settled the estate?
Okay. So there are two
It's the
different
larger
parts
stuff.
to the question.
Okay.
Okay. One is about dealing with cemetery law. And cemetery law is very state-based. And it varies significantly from state to state. So you have to look at where the cemetery is located.
Mhm.
I've had some experience personally with the cemetery in Westchester County in New York. And it is near impossible to really sell a plot, but don't rely on anything that I'm saying. I'm not admitted in New York. And all I know is what other people have told me.
It's
Um,
Jersey.
Okay. So, but still, then it would depend on Jersey law.
Mhm.
I know a little bit about Virginia law. I'm not admitted there, but I was involved in a disinterment of somebody there from King David, and I know that it's not that hard to sell plots in Virginia, but again, it turns very much on state law. Then there was the other part of your question, which I can't remember what it was.
In general, the assets that you find out. Saying the
Okay.
estates sale, and there are assets you didn't know about.
Yes. Okay. So assets that you didn't know about, first have to look at how it's titled, whether it was titled in a trust or whether it was titled in the name of the decedent.
Mhm.
Okay. And it is not unusual to have assets come in a couple of years afterwards that nobody knew about.
Yeah.
By the way, it's always good from time to time to check on the unclaimed property website to see whether there's something hanging around there. We try regularly to look on unclaimed property for any of the estates that we're handling, because it's not that unusual for somebody who is very elderly to forget that they had a certain asset, and then we find it. But if the estate was closed, in Maryland, there's a provision for how to reopen an estate and claim the property. It's just a regular procedure, and it's fine. It works. The issues are, of course, if the personal representative is no longer alive, then one has to go to have a new personal representative appointed. But Maryland has an established process for how that's done. The District of Columbia does also. We just recently did that
Oh, good.
in DC.
How, if you're going to assign a personal representative, you're going to ask, you're going to put that in the will. First of all, I guess you have to ask this person whether they would be willing to do this, and how do they prepare to be the personal rep? What can you tell them?
Okay. Yes, it's very good to ask the person, not to have it as a shock afterwards to learn that they were put in that position that they may not want to do, or may do it out of guilt or something like that. You want to name somebody who is ready and willing to do it. Now, one doesn't have to necessarily explain in advance what the process is, but what is most helpful to the personal representative and unhelpful to a lawyer who wants to make a lot of money is to keep a regularly updated list of assets and liabilities, and keep that with your estate planning documents. So, what bank accounts do you have? Do you have a brokerage account? Do you have retirement accounts? So list the name of the account. It's always good to list approximately how much you think you have in it, and where it's located. Particularly life insurance. On this consolidated list of your assets, say you have life insurance, and who should you call to claim the life insurance? And any liabilities that you have. If you have certain repayments which are made automatically out of your bank account, it's really good to have it on that list also. So a consolidated list of assets and liabilities that will make life and death a lot simpler in a way. Also, what we've suggested to people more recently is to keep a consolidated list of their passwords. So it'll make life, again, simpler for the personal representative or of the successor trustee, if assets were in a trust, to not only have the list of assets, liabilities, but the list of their passwords. And sometimes, particularly if somebody doesn't have any close relatives or people in the area, to have a list of people who should be contacted after I die, and their contact information. Well, that makes me think of a couple of other little things to note. So I had a client for a number of years that was never married and didn't have any children. And the only people who were really involved in his life, because he was physically ill for many years, were those who were paid to be with him. And I did as well. And, I said, Steve, I need to know who your relatives are. Okay, even if they're not getting anything from your estate, because when somebody passes away and an estate is open at the Register of Wills, not only do you have to provide the Register of Wills with a list of the names and addresses of everybody who would be inheriting through the will, but one also has to provide the names and addresses of everybody who would inherit if there was no will. Okay, now this particular client, Steve, he left all of his assets to charities. Okay, but the relatives who would have inherited if he had no will, they had to be notified. Okay, so I remember he just gave me 2 names of people, and he wasn't exactly sure where they lived. So after he passed away, which was a year and a half ago, we had to hire a company, an air search company, to find out, who the relatives really were, because at first I tried to do it through the internet and I couldn't locate the people, and it turned out that the spellings of the names that he gave me weren't accurate. So, we paid, we did find those people, but that we had to do it according to Maryland law, and we were forced to do that by the Register of Wills. So those are good things to keep, lists of, in order to make it the transition smoother and to keep law firms from earning a lot of money.
Barry, just a question for me. There are so many wills that you can pick up online, just for your state, so that it's based on your state. If you don't have a complicated set of assets or family, are those at least a good place to start, or are they too basic and don't cover enough to really make it through the probate type processes?
I'm not sure what I caught the beginning, Beverly, of the question.
I was saying that, they've got so many of these online forms that
Oh,
you
oh,
can
oh.
use
Okay.
to do a will, and all of the forms you talked about are available online now.
Okay.
Are they reliable?
Okay, to note that the laws vary from state to state.
Right.
And
I
if you
said
have an
by
online,
state,
right,
yeah.
if you have an online will, there are 2 things. Number one is make sure that it's something which would be appropriate for Maryland,
Right.
because a generic will may not be appropriate for Maryland. So for example, Maryland has an interesting law which limits the amount of money that can be used from the probate estate for funeral expenses. Okay, but that law can be trumped by, sorry for using that word, or overruled or whatever it is, by a sentence in the will that says that, the certain statute, dealing with limitation of funeral expenses shall not apply to my estate. So every lawyer in Maryland, we stick that in without even thinking in the will, but a generic will doesn't have that. Okay, so that's just an example of that being important. Then
well, I know,
let me
I
tell
was
you.
gonna say, I know that you can, when you go in, you can, if you Googling, I want a will, and it's, and they ask you now what state, so that you get a form for Maryland versus a form for Virginia. So
But
they do that.
you're relying on information on the internet from somebody who you've never met,
True.
who's never interviewed you. You're just thinking that because they say it's valid in Maryland that it is. Okay. Now let me note another aspect of this. Sometimes lawyers really like it when people do these wills, because there may be a problem that the lawyer later on has to resolve. So I will tell you another real case that we had. So there was somebody who married, had 4 children, got divorced, and then he married again. And after many years, he decided he wanted to divorce. He was separated, wanted to divorce the second wife. And he then, this was in Prince George's County, but it could have been any county. And when you're divorced, there's usually 2 different steps. There's the hearing, there's the scheduling conference, and then if it's an uncontested divorce, you still have to have one more hearing in which there's testimony to show, certain things, and then there's the divorce itself. Well, in this particular gentleman, I don't know if you can visualize the circuit court in Upper Marlboro, but so he was walking out of the courthouse after the scheduling conference, and he was hit by a car and he died. Okay. He had done, it turned out, a will that he was able to do online. He neglected to fill out one of the parts. He neglected to fill out the personal representative. Okay, for some reason he had it, he was appropriately signed, witnessed, and everything, but never filled that part out. Okay. And what happened was the children, the 4 children from the first marriage, went to an attorney in my building to handle a wrongful death claim against the driver. And so I was working with that attorney, and he said, well, Barry, can you handle the estate? So I said, sure. And then we saw the will. Okay, so what it is, if you have an otherwise valid will and you don't name the personal representative, or the named personal representatives can't serve for whatever reason, then the surviving spouse is first in line to be the personal representative. If there's no will, then Maryland law says that the children and the surviving spouse have equal priority. But in this situation, because there was a will, the wife, who was in the middle of a divorce, but not divorced yet, she controlled the wrongful death lawsuit. Didn't make my colleague, the attorney who was a personal injury lawyer, happy because he couldn't do the wrongful death claim, because all of a sudden his clients had no longer had any right to drive the lawsuit. And that all evolved because failure to appropriately fill out that online will. So there's my answer.
Well, thank you, Barry. I know we've got one last
got one
question.
question.
Yeah, and then
important
I know we're pressed for time.
Okay, so the question is, if you don't have a close relative to act as your power of attorney, who do you how do you determine who to turn to accept the power of attorney for you?
There isn't a great answer to that, because usually we recommend that someone use a trustworthy relative. If there's no trustworthy relative, then a trustworthy friend. Sometimes it does happen that none of those exists. So this person, the client, would then turn to an attorney or an accountant or somebody else to be the agent under a financial power of attorney. So I know that lawyers do it, although somewhat reluctantly. If there's nobody else around, then that's sort of the final resting place for that.
But it is okay to find a trustworthy friend.
Yes, absolutely. Absolutely. Okay. A trustworthy friend would be willing to do it. Yeah.
Well, this has been, eye-opening. When the it's up about, planning for your final documents in a estate, it seems pretty straightforward, but there are a lot of intricacies that Barry has been able to point out. And really, thank you, Barry. This was very enlightening. The question came up earlier, because people are trying to take frantic notes at the same time. That we will have this, we have been recording the entire event, and it will be up on our website probably by tomorrow, day after at the absolute latest. And I'm going to type it in a second, but Stuart already did. It's at kempmillvillage.org, www.kempmillvillage.org, and we'll have this event captured there so you can go back and rewind and go back into the details again. Thank you so much, Barry, for taking the time to spend with us. This has been marvelous.
Thank you. My pleasure.
We wish you all very much the rest of the summer. Enjoy. We'll be back with other events as the fall comes about. We're going to take a bit of a hiatus. And if there's anything else, please go to our website. We're always looking for volunteers to help, or members, and ideas for future events. With that, Barbara, is there any closing comments from you?
No, thank you. And you've said, I agree. Thank you again, Barry. And yes, we are taking a hiatus this summer, but we will definitely look forward to scheduling, I hope, and maybe even in person, God willing, this fall. Thank you.
And I also would like to thank Karen Fierst, who is also part of our committee, as helping us get Mr. Barry to be part of our program today.
Yes.
Karen, go ahead.
In spite of the topic, I'd like to wish everyone a long and healthy life.
Yes.
Yeah. Sounds good.
With
Okay.
that,
Okay.
thank you, everyone. Have a good
Take care.
week.
Okay.
You too.
Take care.
Thank you. Bye-bye.
Bye.
Bye-bye.